All right, so we're going to talk a little bit about the background of the public charge inadmissibility. Basically, previous to the public charge being rewritten by the Trump administration, or attempted to be rewritten by the Trump administration, USCIS used a 1999 interim field guidance to explain to officers how to implement or how to use the public charge inadmissibility. The Trump administration attempted to change that rule. The rule was implemented. It was then taken to court. When the Biden administration came in, they declined to defend the previous administration's attempt at changing the public charge inadmissibility. And so the interim field guidance from 1999 went back into force. And the idea is this new public charge rule basically takes that interim field guidance and places it into federal regulation, with kind of taking like a policy memo and making it into a more of a, into the Code of Federal Regulations, so it's more permanent.
Bueno, ahora vamos a hablar de lo que es la historia de cómo existe la ley de carga pública. Como se mencionó anteriormente, esta ley de carga pública ha existido desde hace mucho tiempo. Comenzó en la guía que se tenía en 1999, donde se empezaba a hablar ya de la carga pública. Algunas personas la han escuchado más comúnmente en la administración anterior del expresidente Donald Trump, en el 2019, donde se dio a conocer que estos cambios que se le hizo a la guía que ya existía de la carga pública. Después de darse a conocer esta nueva implementación, esta regla se fue a la Corte Federal y de Circuito, antes de que pudiera entrar en vigor, se canceló, y después, con la nueva administración del presidente Biden, se quiso crear una regla que fuera más permanente, sin embargo, distinta a la que se había establecido en la administración anterior, que es la que ahora vamos a estar hablando, la nueva ley y la ley final de la carga pública, que es lo que vamos a estar explicando en los siguientes momentos.
All right, so this very quickly, we're going to go through this just because I want to get to the more important slides. But basically, the Biden administration published a new rule. They went through the rulemaking process. And then December 23rd of last year, the rule went final. So it's in the Code of Federal Regulations.
En el 2021 es cuando se hace la propuesta, se anuncia la propuesta de cómo va a ser la nueva ley de carga pública. En febrero del 2022 se publica esta nueva ley y entra en vigor. Esta es la fecha más importante que tenemos que considerar, que la ley entra en vigor a partir de diciembre del 2022. Es decir, a partir de ese momento comenzamos a aplicar la nueva ley de carga pública.
All right, so we're going to talk a little bit about what the actual rule entails.
Ahora vamos a hablar de qué es lo que significa o lo que incluye la nueva ley de carga pública.
All right, and so here are basically the two things that USCIS is looking for when we apply or make a determination on the public charge inadmissibility. We're looking for two things. Whether the applicant is primarily dependent on the government for subsistence, as demonstrated by receipt of cash assistance for income maintenance. So that would be what's commonly known as TANF, temporary aid in need of families, or SSI, or a subsection of the Medicare program that covers long-term institutionalization at government expense. That's not the Medicare that most people know. This is Medicare, part of the Medicare program that pays for people who are institutionalized in medical or care settings over long periods of time, and the government is the primary payer.
Ok. Ahora vamos a ver cómo es que, ya sea un oficial de migración, un oficial consular o un juez de inmigración, cómo hace esa determinación de una carga pública, cómo se determina que existe una persona puede ser una carga pública y por lo tanto ser inadmisible. Hay dos razones o dos formas en las que el Departamento de Seguridad Nacional va a hacer esta determinación. Número uno es si el no ciudadano ha recibido asistencia pública en efectivo para mantenimiento de ingresos. Esto puede ser, hay distintas formas en las que una persona puede recibir esta asistencia pública. Una de ellas es SSI, que es el suplemento. Otra puede ser otros programas de asistencia en efectivo también como TANF. También puede ser, otra de las segundas razones es institucionalización a largo plazo a expensas del gobierno. Más adelante vamos a hablar un poco más específico de lo que esto significa, pero en general esto podría ser una de las secciones de Medicare, pero únicamente la que incluye institucionalización a largo plazo. El Medicare normal que todos conocemos no es una de las dos razones por las que se puede considerar una carga pública. Eso es muy importante. El Medicare regular no aplica.
All right, so we're going to look at 5 different factors when we make this determination. We're going to look at an applicant's age, their health, their family status, their assets, including any kind of financial support documents that they might have submitted with their application, as well as education and skills. And the reason we're going to look at that is to see if any of these point towards the person primarily being dependent now or in the future on the government for maintaining income.
Estos son algunos de los factores que el Departamento de Seguridad Nacional va a considerar cuando haga esta determinación de si un no ciudadano es sujeto a la carga pública. Un número 1 es la edad, la salud, el estatus familiar, los recursos, los ingresos y en general el estado financiero en el que se encuentra la persona, la educación y las habilidades que pueda tener. La razón por la que se analizan estos factores o se consideran estos factores es ya que ellos van a ser un gran indicativo de si la persona podría en un futuro ser una carga para el gobierno de los Estados Unidos.
So again, this is something we mentioned earlier. We're looking at basically, are they going to receive or will receive or are receiving SSI, TANF. The third bullet is basically add-on programs to TANF. So in addition to receiving TANF, they might receive add-ons through general assistance from state, tribal, territorial, or local cash benefit programs. And that last one is that Medicare program.
Estos son unos factores adicionales que ya los mencionamos anteriormente. Son los factores que consideran el haber recibido asistencia pública en efectivo. El primero de ellos, bueno, ese es el SSI, que es el suplemento de ingreso suplementario. El segundo de ellos es TANF, que es la asistencia en efectivo para el mantenimiento de ingresos para familias. El tercero es un adicional a los que ya reciben la asistencia por medio de TANF. Esto puede ser estatal, tribal, territorial o cualquier beneficio en efectivo. Es asistencia general. Y el último, que es la otra razón de la que hablamos, es institucionalización a largo plazo a expensas del gobierno.
All right, this is probably the most important slide we have on this deck today. These are all the benefits that people can receive that are excluded from a public charge determination. So the first and foremost one, as you see there, is Supplemental Nutrition Assistance Program called SNAP. That's the federal program. In California, it's called the CalFresh, or how California implements it is the CalFresh program. We are not going to look at CalFresh under a public charge inadmissibility determination. In addition, Children's Health Insurance Program, so people will receive subsidies for children's health insurance through that program. We're not going to look at that. Any kind of Medicaid or Medicare, other than that long-term institutionalization, we're not looking at that. Any kind of housing benefits, so people receive Section 8 vouchers or local housing benefit vouchers, we're not going to look at that. And then any kind of preventative medicine, immunizations, testing for communicable diseases, COVID-19 vaccines, treatment, anything else that we do not specifically mention on the last slide, TANF payments, local add-ons, SSI, or long-term institutionalization government expense. If it's not on that slide, that previous slide, we are not going to look at it.
Ok. De los beneficios que no se incluyen, no se consideran al momento de hacer una determinación de si un no ciudadano podría ser una carga pública, son los siguientes. Es muy importante que tomen atención a esta parte en específico, porque lo que voy a mencionar ahora no se incluyen. El primero es el programa de asistencia nutricional suplementaria, el SNAP, ese no se considera. El programa de seguro médico para niños, conocido como el CHEP, tampoco se considera. Medicaid no se considera a menos que sea parte de institucionalización a largo plazo. Beneficios de vivienda tampoco se consideran. Vacunas, pruebas de detección de enfermedades transmisibles, vacunas, pruebas y tratamiento contra el COVID tampoco se considera, y cualquier otras que no estén enumeradas en la regla. ¿Cuáles son las que nosotros enumeramos anteriormente? El SSI, hablamos de TANF, los adicionales que se agregan al TANF y la institucionalización a largo plazo. Esas son las que mencionamos anteriormente que sí se consideran. Las que están en este momento no se consideran.
All right, and there's a lot of other programs that we're not going to look at as part of the public charge and admissibility. The two that I want to point out here are pandemic-related cash assistance programs, so any kind of pandemic payments we're not going to look at. We're also not going to look at EITC, so Earned Income Tax Credit, or any kind of tax credit deduction. Anything like that, we are not going to look at.
Estos son otros ejemplos de los beneficios que no se consideran. Los más principales que ustedes deben de considerar es todos los programas de asistencia que se dieron durante la pandemia. Eso no se considera. Tampoco todas las deducciones o créditos fiscales que pudieran tener tampoco se consideran. Viene otra lista más ahí de otros más como desastres naturales, beneficios en eventos no ganados, asistencia en casos de desastres. Todos estos beneficios no se van a considerar en la determinación.
This is another important point. When we do the public charge inadmissibility determination, we are not looking at the applicant's family, so any family members that might be receiving any of those benefits. We are only looking at the applicant. So if the applicant's children are receiving benefits, if the applicant's spouse is receiving benefits, it does not matter as long as the applicant themselves is not receiving the benefits we mentioned previously. We will not, the public charge inadmissibility will not apply to them.
Okay. Los beneficios recibidos que mencionamos anteriormente, únicamente vamos a estar poniendo atención a los que recibe el aplicante o la persona que está pidiendo el beneficio migratorio. No vamos a considerar los beneficios que hayan recibido sus familiares. Es decir, si sus hijos reciben beneficios económicos, asistencia pública, si su esposo, su esposa recibe asistencia pública, eso no se considerará como un factor, ya que solamente vamos a considerar al aplicante individual. Es decir, solamente a la persona que está pidiendo admisión, que está pidiendo una visa, que está aplicando para la residencia, solamente los beneficios que esa persona ha recibido o que está recibiendo van a ser considerados, no de los familiares.
There are some groups that are exempted from the public charge inadmissibility. The big ones we're going to talk about are people who are in the United States who have temporary protected status, people who are admitted to the United States or have been granted asylum or refugee status. T and U non-immigrants, those are non-immigrants who have received a T or U visa. Those visas are for people who are victims of crime or victims of human trafficking. And then also people who have self-petitioned under the Violence Against Women Act.
Las siguientes categorías son las personas que están exentas de esta ley de carga pública. ¿Qué significa estar exento? Que la ley en general no aplica para ellos. Es decir, si ellos reciben cierto tipo de beneficios, no les afecta porque ellos no están sujetos a esta regla, están exentos de la regla. Y estos son algunos de los grupos, los principales, que sería los estatus temporal de protección, que sería conocido como el TPS, las personas que tienen un estatus de refugiado, personas que tienen un estatus de asilo, los aplicantes para lo que se le conoce como la visa T o la visa U. La visa T es para tráfico humano y la visa U para víctimas de crímenes. También a los autopeticionarios de VAWA. VAWA es el acto en contra de la violencia a la mujer, que también aplica para hombres. Entonces, estas personas que están enumeradas no están sujetas a la ley de carga pública, es decir, no les aplica a ellos.
This is also important. Simply having taken TANF payments or SSI or have been using the Medicare program in the past by itself is not enough to trigger the public charge inadmissibility. USCIS officers have to take in the totality of circumstances and use those 5 factors we discussed before: age, health, family assets, resources, and education and skills. So just having received the benefits in the past is not enough to have someone trigger the public charge inadmissibility.
Es muy importante considerar que para que se haga una determinación de si uno ciudadano está sujeto a la ley de carga pública, el estándar que los oficiales de inmigración, que el oficial consular o que el juez de inmigración va a utilizar para hacer esa determinación se llama la totalidad de las circunstancias. ¿Qué significa esto? Esto significa que vamos a considerar todos los factores para tomar una determinación. Se va a considerar lo que ya mencionamos anteriormente, como es la edad, la salud, el estatus familiar, los ingresos, los recursos económicos, la educación, las habilidades. Todos estos factores se van a considerar al momento de hacer la determinación. Por ejemplo, si un aplicante ha recibido beneficios económicos en el pasado o está recibiendo, eso por sí solo no será conclusión de que la persona es inadmisible por ser carga pública. Es decir, se considera como factor, pero eso aunado a los demás factores se va a considerar no solamente uno de los factores, no solamente si ya recibió beneficios, sino que se consideran todos los factores al momento de tomar esa decisión.
So there's some other circumstances. So basically what this slide is saying is if someone was in a category that was exempt from the public charge ground of admissibility, as you mentioned before, TPS, VAWA self-petitioners, TNU visa holders, and asylees and refugees, and they received those benefits, and then they moved out of that category, we're not going to trigger the inadmissibility for that because they were eligible for those benefits when they received them.
Existen algunas circunstancias especiales. Anteriormente les mencionamos que había un grupo de personas que estaban exentas de lo que es la ley de carga pública, como por ejemplo las personas con estatus de refugiado o estatus de asilo, de protección temporal como TPS. Estas personas en el momento que están en un estatus, por ejemplo, de refugiado, tienen acceso a ciertos programas de asistencia pública. Entonces, si estas personas cambian de categoría en el futuro, el hecho de que hayan recibido esos beneficios en el pasado mientras eran elegibles no les afectará ni se considerará como en el momento que se haga la determinación de la carga pública. En otras palabras, el hecho de que un aplicante haya recibido beneficios en el momento de que tuvo un estatus migratorio distinto no va a ser un factor que se va a considerar, ya que en ese momento esas personas estaban exentas de que se les aplicara la ley de carga pública.
All right, so our last slide. So this is some resources, and I can bring this up and put them in the chat later, but these are some of the resources that people can use. The one I'd like to point out is the last link. It provides pretty easy to read flyers in a number of different languages that explains the public charge inadmissibility, as well as some of the things that might trigger it. They use like a yellow, green, like a stoplight, green, yellow, red thing to explain it. So, and I can put that in the chat, but it's a good resource. I think that is it.
En esta última sección les vamos a proveer de unas páginas web que ustedes pueden acceder y van a encontrar más información de lo que es la ley de carga pública. Estos son específicamente, me quiero enfocar en la última página web. Ahí podrán encontrar ejemplos específicos, podrán encontrar más información, un poco explicado de una forma más sencilla y en diferentes idiomas. Y esto sería todo por el día de hoy de nuestra parte. Muchas gracias.
Thank you so much, Jeff and Anna. I will go ahead and share my screen. So thank you so much for being here. There are so many misconceptions and fears surrounding public charge for immigrant households and families. So it's great to hear directly from USCIS and, learn exactly what is considered in a public charge determination. It's so significant to have you here today, helping us dispel these misconceptions. So thank you, Jeff and Anna. All right. So we will be transitioning into the presentation from the CalFresh team here at the San Diego Hunger Coalition. From here on, for the rest of the event, all Spanish interpretation will be in the Spanish interpretation Zoom button. I will put the instructions in the chat on how to enable Spanish interpretation. As a little reminder, again, you'll need to click those 3 dots labeled more, click the interpretation button and select Spanish and turn original audio off. All right, so we do recognize this event is meant to focus on dispelling public charge misconceptions. However, the CalFresh team here at the San Diego Hunger Coalition focuses on nutritional and connecting families with nutritional assistance. And we know many families experience barriers when it comes to applying for CalFresh benefits, especially because of these fears. And so we wanted to discuss best practices when connecting families to these CalFresh benefits. And as a little reminder, we will have a portion of the event dedicated to questions at the very end. So if you do have any questions, please save them for the very end during the facilitated FAQ. All right, go ahead and get started. All right, so what is CalFresh? Well, CalFresh is also known as SNAP. You might have heard Jeff and Anna say SNAP specifically during their presentation, but here in California, it is known as CalFresh. It is a federal food assistance program that provides recipients with monthly benefits that can be used to purchase food at grocery stores, farmers markets, and certain online retailers. It is especially significant because it provides families with access to purchasing power to be able to purchase nutritious, healthy, and culturally appropriate foods. These benefits are delivered on an EBT card. It looks just like a debit card and it works just like an old-fashioned debit card. You will swipe the card, put in your PIN, and you'll be able to purchase your groceries. We have a little example of what that card looks like right there on the left. Right. So who is eligible for CalFresh? You do not have to be a US citizen in order to be eligible for CalFresh benefits. There are different types of immigration statuses that may provide you with CalFresh eligibility. To list them first, we have legal permanent residence of at least 5 years. If you have been a legal permanent resident for less than 5 years, you still have access to food assistance through the California Food Assistance Program, or CFAP for short. Additionally, other immigration statuses that may be eligible for CalFresh include refugees and asylees, non-citizens who have had deportation withheld, Cuban and Haitian entrants, conditional entrants, parolees for at least 1 year, survivors of domestic violence, U visa holders, applicants, and then victims of human trafficking and other crimes like T visa. We have heard from a lot of application assisters questions about different immigration statuses. I know we have a lot of refugees here in San Diego who might be here under a tourist visa or under TPS or temporary protected status. Unfortunately, if you do not fall under one of these immigration statuses, you may not have eligibility for CalFresh. However, we do want to note and emphasize that just because one member of the household is ineligible, that shouldn't stop the other members from being eligible and from being able to apply for CalFresh benefits. So how exactly does CalFresh look different for immigrant and mixed status families? Well, they experience a lot of different barriers. There are barriers when it comes to initial application and even maintaining benefits, but I'll go ahead and pass it off to Shelley to talk a little bit about these.
Yeah, so I just really wanted to put a context setting slide because there are a lot of barriers to CalFresh participation for immigrant and mixed status households, and these include these include kind of decisions like public charge or considerations like public charge or sponsor deeming and liability, language or literacy issues, and lack of knowledge about the program and mandatory verifications. And so I'll just go into like public charge, which is the huge topic of this presentation, and it is just the perception that participating in SNAP or public benefits or in-kind public benefits could affect immigration status or hurt a non-citizen's chances of becoming an American citizen, and it's simply not true. CalFresh is a safe resource to use, and it's important for non-citizens to know that they will not be deported, denied entry to a country, or denied permanent status because they apply for CalFresh. And so we just know that non-citizen eligibility for SNAP and CalFresh is complicated, and it's really just essential to understand that like it's there's issues like citizen sponsorship, deeming, and special income rules and reporting can affect the decision to apply for benefits. But it's just like it's really important to understand like how the policies are actually laid out and why communication is really critical so that people can make informed decisions. There's really real opportunities to reach out to more eligible people. And today we're just going into the nuances of CalFresh benefits for non-citizen households, just to let you know that it's safe, and there are like a few additional like asterisk points where you would have to kind of ease a client's fears, but we hope to cover all of those today. Alrighty, I will hand it back to Anna.
Oh, didn't realize I was muted. Thank you, Shelley. All right, so moving on to one of the biggest barriers to accessing CalFresh for immigrant and mixed status families, and that is sponsor deeming. But what exactly is sponsor deeming? Well, some CalFresh applicants are going to be required to sponsor deem, which is the process in which the county looks at the sponsor's income to determine the amount the sponsor should be providing for the applicant. In order to access CalFresh benefits, some applicants are going to have to provide their sponsor's financial information. And that can be a big barrier because, again, not everyone is in contact with their sponsor. And there are a lot of misconceptions when it comes to sponsor deeming. We just wanted to cover a few of those and let you know that first, the sponsor's income is not going to be counted against the applicant in the CalFresh application. So we do recognize a lot of families get scared or they might think that they won't be eligible for CalFresh because their sponsor might make too much. But again, this is not the case. The sponsor's income will not be counted against the applicant. Second of all, the sponsor will most likely not be financially obligated to pay back these CalFresh benefits for the applicant. Again, to our knowledge, the state of California has never requested repayment of Medi-Cal, CalFresh, or CalWorks from a sponsor. So this is a safe resource for families to access, and the sponsor should not be obligated to ever pay back these benefits. And additionally, applying for and receiving CalFresh will not affect the applicant or the sponsor's immigration status, either current or future. Applying for and receiving CalFresh benefits are not going to stop you or stop an applicant from, becoming a citizen in the future, and it will not affect the sponsor's immigration status as well. Okay. But applicants are not going to be required to sponsor deem on the CalFresh application if they meet a sponsor deeming exemption. And to list them out, this can include if the applicant is a naturalized citizen, if they have 40 qualifying work orders or roughly 10 years of work history in the US, if their sponsor has passed away, if they have no sponsor, if they were perhaps a refugee or an asylee, if they arrived before December 19th, 1997, if they are a survivor of human trafficking, domestic violence, or other serious crime, or if they are under the age of 18. But we do recognize not everyone is going to meet a sponsor deeming exemption. And so if sponsor deeming does apply to the applicant, they will have to provide the sponsor's financial information on a form called the SAR 22 form. There are some barriers to this. First of all, it can be hard when not every single family is in contact with their sponsor. So it can be difficult to, first of all, get this application filled out in order to connect families to CalFresh benefits. Additionally, this form must be filled out by the sponsor every 6 months for a majority of households receiving CalFresh benefits. So that is another barrier that we have to keep in mind. But families do have some options if they are not able to get their sponsor to fill out this form. So what other options do families have? Well, first, they can declare indigency if they meet these following qualifications. If their income plus any assistance received from their sponsor is at or below the 130% federal poverty level. If they qualify for indigency, clients can sign the 0999 USCIS indigency exemption form. And here they don't have to provide the sponsor's information, financial information. They only need to provide their sponsor's name and contact information if it is known. The form does get sent to USCIS, but there has been no consequences or impact seen by any application assister or by any applicant. Second of all, if they don't feel comfortable either deeming their sponsor or filling out the USCIS indigency exemption form, then sponsored individuals may choose to just opt out of the application and apply on behalf of their eligible family members. This situation is most typically applicable to families that have children under the age of 18. And this is because minors, again, under 18, are not required to provide sponsor information regardless of their immigration status. So typically this is easiest for families, again, who have children under 18. We do want to note that a portion of the income from whoever opts out will be included in the application or prorated. However, the county will never require individuals who opt out to provide their immigration status information. So if an individual doesn't feel comfortable sharing their immigration status, they can opt out and they can keep that information completely private. The county will never request it. All right, and I'll go ahead and pass it off to Stephen to talk a little bit about another barrier that families face, which can be proof of status verifications.
All right, thanks, Anna. Yeah, so when a family or household applies for CalFresh, they will have to provide status or proof of their immigration status. So this is to ensure that only those families that are eligible for SNAP receive the benefits that they are eligible to receive. So in order to ensure this, state agencies must verify the immigration status of those who are applying for benefits. With that said, they can only verify for those individuals who are applying and nobody else. So state agencies are not required to verify the immigration status of anyone who is applying for SNAP on behalf of others in their household. So for example, that might be a non-citizen parent, for example, trying to apply for benefits for his or her US citizen children in the household.
Yeah, thank you, Stephen. I will take over on the slide because it's very difficult to hear you, but we so appreciate you. Yeah, and so immigrants may be asked to provide proof of status to get benefits. So these are some proof of status verifications that immigrants might have to bring. So it's a copy of the green card, a copy of the most recent paperwork for a U visa, T visa, asylum, refugee, or parolee status, or WAWA petition. And then so it would just have to be like documentation for that. And then naturalized US citizens may be asked to provide a copy of their US passport or naturalization papers. And this is really important. If this only really applies for people in the household that are applying. So for those that are not applying, they do not have to provide any proof of immigration status because they have opted out. So we want to emphasize that point over and over again throughout this presentation about the opt-out process and how someone will never be asked for additional immigration status information. They might be asked for income information for the prorating, but not immigration status information if they're not applying or part of that household. And we can go into the next slide. And CalFresh applicants are required to provide a social security number. So if an applicant does not have a social security number, they must provide a proof that they are applying for an SSN or good cause for not applying for one. But this is typically like good cause only really extends for 1 month for people within the process of applying for a social security number. We know this is quite difficult for those that are new refugees applying for social security numbers, and those are the only eligibility barriers to applying for CalFresh. So the county will extend good cause for 1 month and then just figure out like, okay, what part, at what part of the process is someone applying for the SSN number, and eventually required to get a social security number to be eligible for CalFresh. So the county will not seek an SSN from an individual applying on another's behalf. So any authorized representatives or CBO sisters, the county will not seek your SSN for someone else's CalFresh application.
Yeah, and I did want to mention an example of what good cause can look like. An example of good cause could be when an applicant is waiting to gain access to a document that they need in order to apply for a social security number. One example could be their birth certificate. So if an applicant doesn't have access to their birth certificate and they need to wait in order to gain access to that document, that can be an example of good cause. And again, it must be a valid reason for not having an SSN or having applied for an SSN. All right, moving on to the next slide. I'll pass it back to Sean.
Alrighty, and just for proof of status verifications, under no circumstances may a state agency require any information about non-applicants. We just want to emphasize that for those of you helping with mixed status households apply. Deny SNAP to any applying household members because of a non-applicant household member. So the only reason why they would probably deny someone from SNAP is based off the income, not because of a status, immigration status. And then try to establish or verify immigration status through any means other than these procedures. So mostly the state or the county agency will just go through the SAVE program, which stands for Statewide Alien Verification System or Verification System. Yeah, thank you. So these are the ways that they will go to verify immigration status. And so the household has the primary responsibility for providing proof of immigration status. So this was one of the barriers to providing verifications. But the state agency must assist the household in obtaining verification of immigration status if they choose to opt into that. And then the SAVE system is really great. I think it's like a connection with USCIS's kind of database on immigration status that the county can get information about for the CalFresh case for immigration status and proof. And now go back to Anna.
Thank you, Shelley. All right. So we do recognize it is not easy for families to apply for these benefits because there is so much fear still around and there is a bit of information. So again, we just wanted to clear some additional misconceptions that families may still have when it comes to applying for CalFresh benefits. And first of all, we just want to drive the point home that applying for and receiving CalFresh benefits is not going to affect current or future immigration status of the applicant or the applicant sponsor. I know we said this earlier, but we just want to drive that point home because again, CalFresh is a safe resource, and is not going to affect the immigration status of any current recipient, the recipient's family, or the recipient's sponsor. Additionally, San Diego County will not report immigration status information to immigration authorities. Any information that is shared on the CalFresh application will only be used to check for CalFresh eligibility. No one is going to be getting deported over information shared on the CalFresh application. Again, information will be staying private, and again, only used to check for eligibility. Additionally, we also said this earlier, but members of the family who opt out of the application will never have to disclose their immigration status at any point of time, either during initial application and during recertification of benefits. Overall, CalFresh is a safe resource for families to make use of. And we recognize many immigrant families are scared to make use of CalFresh, but again, it is safe for families to access.
Yeah, and I also just wanted to add a point. There's a huge difference between USCIS and ICE. USCIS is the administrative body, and ICE does not really share information with ICE. So a lot of the information gets sent to USCIS, but they can't, do anything about it and enact anything about it unless there's like a deportation warrant out there. And thank you, Jeff.
Thank you. All right. But we do highly recommend, if you happen to know a family who might still have some fears around this, it would be great to connect them with a CalFresh application assister, because again, these individuals are trained application experts, and many of them speak multiple languages that are relevant to the communities that they serve. These assisters are able to provide in-depth support throughout the entire application process. I know we have a few of them here on this call today who do amazing work for refugees, and they are able to, advocate on the applicant's behalf. They are amazing resources here in the community, and I know that they'll be able to provide fantastic help and resources for immigrant families. We do have a full list of application assisters all over San Diego on our website. These slides, again, will be sent after the presentation is over, so don't worry about grabbing any links or anything right now. But we do highly recommend connecting families with an application assister. And additionally, we wanted to share another resource that immigrant families may make use of, and this is WIC, which stands for Women, Infants, and Children. It is another federally funded nutrition program that can provide pregnant individuals, infants, children, and individuals who were recently pregnant with access to healthy foods and other resources like breastfeeding support and cash benefits for other healthy foods. We wanted to point out this resource in particular because there are no immigration requirements for WIC applicants. Additionally, families can receive both CalFresh and WIC. They're not mutually exclusive. Families can have both. All right, and I'll go ahead and pass it off to Shelley.
Alrighty, so I just wanted to go over a few program guides and resources that we cited throughout this entire presentation at the SDHC side, and we referred to the HHSA program guide, which is public on HHSA's program guide websites. I think it's like /stamps. We'll be sending in follow-up information after this presentation, but I also just wanted to re-emphasize CFAP as the California Food Assistance Program, since lawful permanent residents between years 0 to 5 are ineligible for CalFresh, and up until that point they cannot apply for CalFresh. So there is this interim program that is administered by the state of California that everyone can apply for. I think there's around 30,000 people currently enrolled in the program. That's a great program, and we really want to expand access to that. And then just to emphasize qualifying quarters, this is when applicants, for CalFresh applicants to have qualifying work quarters for exemptions to sponsor deeming, they will have to have 10 years of working experience of 10 years of working quarters without receiving any public benefits. So if, you know, a client is worried about just like that extension of time, you can say like, hey, like, you know, you need this in this interim, it's going to be okay. Like, you know, if you need it for 1 quarter or a few quarters, it'll just extend a little bit more time for exemptions to sponsor deeming. But it is, you know, it is a resource that people are eligible for and they should be applying for. And if it's a dire situation, I think it's necessary to help apply for public benefits. And then for Section 11, refusal to provide legal non-citizen documentation. So this is when, so this is for households that want to opt out and don't want to provide any additional information. The county will will say that someone is an eligible non-citizen, and then just they don't have to collect any more immigration status information. The only information that they will be collecting is probably income for the prorating for the opt-out portion. And then just reporting of illegal non-citizens, there's a lot of fear that there's deportation attached to just applying for CalFresh or like going into public benefits and applying for public benefits. It's simply not true. It is only going to be an issue if someone in the household is like, oh yeah, this other person in the household has a deportation warrant out there. That's when the county has to act on that information. So there's no other situation where the county would have to act on that information to deport illegal non-citizens. But you know, like we said, we really emphasize that at no point in time does anyone have to disclose their immigration status throughout the entire process. So we want to keep everyone safe and protected. And then I'll go on to the SNAP federal guidance for non-citizen eligibility. There's 2 differences between the HHSA program guide and this SNAP USDA guide, and it's that the SNAP one is a lot longer and more comprehensive, and then the HHSA program guide is more condensed. So they both cite legal language for this, but I also wanted to highlight sponsor liability. We know that, to our knowledge, sponsors have not had to pay back benefits, even if they sign like an affidavit of support to keep immigrant household above 125% federal poverty level. It's only if the state is going to pursue legal action and sue someone, but in California that has not happened, and so sponsors really have a very, very low likelihood of paying back benefits, and I would say close to 0. And just some takeaways from this section. CalFresh is a safe resource for eligible non-citizens to use, and verification is required for only household members applying. So state agencies cannot use the immigration status of individuals who choose to opt out against the applicant's information. Oh, yes. And thank you, Jeff, for the clarification. I will kind of talk about that afterwards on this. And there are pathways outside of sponsor deeming. So you can help applicants find sponsor deeming exemptions. So with the 40 working quarters, so 10 years of working without receiving benefits or filing for indigency. And then immigration status of applicant and the sponsor will not be affected by CalFresh. And then Jeff has a really great point. Thank you for the clarification, by the way. USCIS is a benefits adjudicating agency within the Department of Homeland Security, and as such does not have law enforcement function. However, they do interact with ICE at times, for example, as it relates to applicants who may be found removable under US law. So this would apply if someone, you know, kind of told HHSA that, hey, someone has a deportation warrant out there, then HHSA would have to ask USCIS, like, hey, is this true? And then USCIS would send something to ICE. Is that right interpretation, Jeff, if you want to clarify?
The way I would describe it is, so if someone applies for a benefit and we find them that they have some kind of ineligibility or something that makes them removable from the United States under the law, we would then work with ICE to notify them and say, hey, this person has been found inadmissible and removable under this section of the law. But in terms of like looking at public charge inadmissibilities specifically, we wouldn't talk to ICE about something like this. This would be something specifically where someone was found inadmissible and removable. We would then contact ICE, because as part of that immigration triad within DHS, you know, there's CBP, ICE, and is this person eligible for this benefit, yes or no? If the person is found inadmissible and removable, then they might be referred to ICE for them to take over in the law enforcement role. Hopefully that makes sense.
Yes, that does. Thank you so much. Yeah, thank you for that clarification. We can go on to the next slide. And so these are resources, they will be shared out that we have cited and looked at, and that we like to use at the Hunger Coalition, just to look at non-citizen eligibility for CalFresh. And this is our contact information. We'll be sending that out in a follow-up email, but without further ado, I will hand it over to Miko from Legal Aid Society of San Diego. Thank you so much.
Hi, thank you. So I'm going to come at this from a little bit of a different angle. I am an attorney, so we do evaluate public charge eligibility. So I'm going to start with a conversation about who legal aid is and why you should seek legal advice, or in what circumstances you should seek legal advice, and then give you some resources where you can find legal advice in San Diego. So let's see, do I have control or does someone else? Perfect, we'll just go with it. I don't know who did that. I'm not really good at reading slides. I think everybody can read a slide, but basically, Legal Aid Society of San Diego is a local nonprofit. I've been working at Legal Aid Society for 27 years doing only immigration law. If you qualify for our services, we help people who are lower income residents of San Diego County. All of our legal services are free. So you never have to pay for anything. So we are a good resource for people who have questions about how is public charge going to affect me? Should I ask for benefits? And you don't have any money to pay an attorney? That's when you would probably contact Legal Aid or one of the other agencies that I have listed on at the end. Jump. Is somebody else controlling this? Okay, I'm sorry, I can't figure that out. So where to find us? We do have 3 offices in San Diego County. So we do have very broad coverage. We're all the way up in San Marcos. We are in central San Diego. Some people might call it Old Town. And then we are in South Bay. Some people might call it National City, but we're only allowed to call it San Diego. So we do have broad coverage. We have regular office hours. You're welcome to check out our website to get more specific information. Next. What we do, Legal Aid Society does not only do immigration. Most of you are probably familiar with us and what we do. You might not be familiar with everything we do because we do a lot. Again, from my perspective, my team only does immigration. So I'm going to jump to the next slide as to what our team does. We are comprised of 4 attorneys who only do immigration. We have 1 fully accredited rep who can represent people both in immigration court proceedings as well as before USCIS. We have 1 partially accredited representative who can represent people before USCIS. We have an administrative assistant. We take volunteers who help us, and we have law students and interns who are helping us. So we're a much larger team than when I started 27 years ago, and we were a team of 2. So now I can't even count in how many people we have. Moving on. The kind of immigration cases we handle vary. And people have mentioned before naturalization, and that's the process by which a lawful permanent resident seeks to become a US citizen. That's different from citizenship, where a person has a claim to be a US citizen, not through a process, not through passing a test, but by virtue of their parents are or were citizens, their grandparents are or were citizens. So it's a way of receiving citizenship, maybe never having set foot in the United States before. Doesn't matter. Somebody can have a claim to citizenship that way. That's always one of the first things that we do check, especially when it comes to people asking us about public charge. How will this affect me? The very first thing we always do is check if this person is a US citizen. A US citizen is not subject to what Jeff alluded to, which are the grounds of inadmissibility. Public charge is a ground of inadmissibility. The inadmissibility grounds are reasons why the government won't allow a person either to physically enter the United States or to legally enter the United States. And public charge is one of those grounds. But if you're a citizen, none of that applies. So getting citizenship is a real big deal for us, and we try to get as many people citizenship as possible. We also work on the defensive side of things, which is removal defense. So if somebody does find themselves in immigration court proceedings, the government wants to try to deport somebody, we can and we do go into court with those folks and help defend them against deportation. Next slide. Why seek legal assistance? So this has got a lot of information on the slide. My PowerPoint comes in one at a time so we could go through them each individually, but we'll try to get through this. Every person's set of facts is different. And we have to keep that in mind, that even siblings within the same family might have different rules applying to each of them. So it's always important to get as much information as you can before you submit any kind of application to USCIS. Not going to go there. We will always evaluate the process start to finish to determine, okay, what is it that you're asking us? What do you want to know? Public charge? We talk to you about public charge. We talk to you about receipt of benefits. We talk to you about how to overcome any potential issues. We will walk you through the entire process. If it comes out that maybe you could be placed in removal proceedings, that this could result in you being put in immigration court proceedings, then we talk to you about what are the defenses. We go through risk tolerance analyses. There's a whole lot that goes into this. So it's not just a narrow conversation about public charge. We look at the person holistically to ensure that all assistance is provided. That includes, if you come to us with a public charge question, and then there's a question that you have about, well, how do I apply for these benefits? The San Diego Hunger Coalition is a great resource. We also have the Consumer Center for Health Education and Advocacy, which is under the legal aid umbrella. And we do also provide assistance, especially when you have a case where you've been denied benefits. And then legal aid can come in and try to help with that. Maybe somebody has already heard through a presentation that, well, I just don't qualify, I'm not going to apply. That's especially the kind of person that we would like to talk to evaluate, to ensure that that really is the case. If there is a chance that you can apply, we will discuss that with you. And then I already talked about that, so we could go on to the next one. Seeking out qualified legal services. This is a critical note. And I know that it's a very high priority for USCIS as well as us. Bad help is probably worse than no help at all. I am very reluctant, especially because, in certain cultures, notary, also a notario, those folks, notarios in Mexico, por ejemplo, they go through school. they get a degree, they are allowed to give legal advice. But in the United States, a notary public, or sometimes they shorten it to notary, those folks are not qualified to give legal advice. And that cultural education needs to take place to warn people away. People who do taxes, people who book your flights, people who are notaries are not qualified to provide legal advice. And we need to make sure that we have enough resources to steer those people to good quality legal advice. I think you can read all of this. I don't think I really need, all of these slides will be made available to you. I did provide them, and so they can be made available to you. We can go on to the next slide. What you can do to help. My recommendation is if anything goes off in the back of your head, I'm not really sure if this is a good idea. Or, well, I know this to be true, but I'm not sure about this. There is no downside to sending a person to seek free legal advice. The more education a person has, the more that they can own their own process. It's a form of empowerment to give them information. And so we always strongly encourage that. So if a person has no immigration status, they're a great candidate to refer in order to discover if there's a way to get legal immigration status. For DACA recipients, I know that there was a question earlier in the chat about DACA and how this affects people and do they qualify. I think that this is a really good time to note that DACA is in the balance, and that anyone who receives DACA at this point in time has to be screened for long-term legal options rather than settling for what they have today, which is basically it's work authorization eligibility. And that's it. So you really want to look for long-term options for folks. If a person is a lawful permanent resident or LPR, then there should be a conversation about, do you qualify to apply for naturalization to become a US citizen? If not, why not? How long will it take? How can you prepare yourself? And then for US citizens, they're a US citizen. Why would I refer them to an immigration attorney? Well, maybe they have family members that they would like to immigrate, and we can also help with that possibility. Providing safety planning information. When you get these PowerPoint slides, that will be a live link. You can click on it. It will take you to resources on how to help prepare people who are not citizens in the eventuality that they are picked up in an immigration raid, or their application is denied and they're placed in removal proceedings, what kind of documents to have, who can you entrust your children to be picked up from school, things like that. Very important information. Next slide. We do have a removal defense clinic. As I mentioned earlier, we do represent people in removal proceedings. So this is simply a resource page. If any of your clients find that they are in removal proceedings, they would like representation or at least an orientation on what to expect, then they can call this number on Wednesday mornings. Next slide. And this San Diego Rapid Response Network is a local network to report if anything is happening. They just came to my house and arrested my husband, or there is a raid going on at the supermarket right now, or this CBP officer stopped me and asked me for documents and I was just walking down the street. Any of that kind of stuff, you can always call the Rapid Response Network. If this is not appropriate to them, they will provide you referral information to where you can better have your concerns addressed. Next slide. And then this is our office. Our intake line is right there. You can also go online to request assistance, or you can walk into our office. The addresses were given on earlier slides, and you can always fill out a manual application. Again, we will need all of the names of all of the adults in the household and the income information for all members of the household, because our services, again, are free to lower income folks. generally speaking, not 100% of the time, you have to fall below 200% of the federal poverty guideline. So we're working with the same demographic here. In certain instances, we can bump it to 250, but not generally. So this is just something to keep in mind when you do find somebody who you think could be an appropriate referral resource. And I had actually modified my PowerPoint because I thought I was going to be sharing a screen. I had added on the contact information for 6 other agencies in San Diego that are nonprofits who provide free information about public charge as well. I will send that updated PowerPoint to Anna, and then she can go ahead and substitute this new PowerPoint for the other one. So I'm sorry, I've done public charge presentations for so long. There is one thing I really do need to throw out there. We talked about sponsors and we talked about deeming. I think one part of the conversation that was not addressed in this conversation was how to get rid of the need for a sponsor and how to get rid of the affidavit of support. Remember, we talked about the reporting to USCIS and stuff like that. There's stuff going on from the last administration through this administration, how that information is used. But if a person who is recently immigrated and somebody did an affidavit of support, which is a required document for family members, that person who did the affidavit of support is called the sponsor. Now, if the person who immigrated has 40 qualifying quarters, which was also addressed, you don't need that affidavit of support. And if you did have an affidavit of support and you accrue those 40 qualifying quarters, the affidavit of support goes away. So you're no longer, you don't have a sponsor at that point. Okay, if the person naturalizes and becomes a US citizen, then there is no affidavit of support requirement as well. Obviously, if the person is deported, it goes away. If the person passes away, it goes away. I wanted to make one small clarification that if the sponsor passes away, the sponsor's estate will be responsible for if, and we already established that that hasn't happened, but if the government comes back and says you need to pay back the benefit, the estate of the sponsor would still be liable up to the point of death of the sponsor. Sorry, I'm an attorney. I deal in technicality and minutia, so I apologize for geeking out on that. With that, I will just stop.
No, that's great information. I really appreciate that you're talking about like how to get rid of like the sponsor deeming exemption with getting rid of the affidavit of support, which is what legally binds the sponsor to being fiscally responsible for the sponsored person. So yeah, we really appreciate that additional information. We will be speaking about the affidavit of support that way. So thank you so much, Miko, for presenting and just providing this really amazing information. And we know now to come to legal aid and refer like so much more heavily over if there's any immigration issue, then of course, like it's so enlightening to hear that there are pathways to just get immigration or just to get naturalized, and there are other options than just dealing with like what applicants and households have. So thank you so much for the work that you do. And yeah, we will get onto the facilitated FAQ now. And thank you so much, Jeff and Anna, for providing additional context and information throughout the interview as well. We are opening this up to everyone in the room. If you have any questions, if you're teaming with them, please feel free to please feel free to unmute yourselves or just type in the chat. I think I saw a question very, very early on in Spanish.
So I do understand we addressed some of these questions earlier, but I did want to just go over some of the ones that were asked in the registration link. The first of these was, will families or children ever have to pay back benefits that they receive? And the answer to this would be no. Families are not going to be asked to pay back these benefits. If they are receiving CalFresh benefits, their children aren't ever going to have to pay them back as well. Also opening this up to Miko and Jeff and Anna, if you
Not actually, the one thing I did want to mention, I think I saw it in the chat and Miko mentioned it. Someone asked about DACA recipients specifically. So just to clarify, DACA is a form of deferred action. So they are not one of the categories under which that are exempt from public charge and admissibility. So if a DACA recipient was to, as Miko mentioned, like as a long-term option for lawful permanent residents, if they received one of those two benefits we talked about, cash income maintenance or long-term institution government expense, and then tried to adjust status, green card, they would be subject to the public charge and admissibility because they were not in one of those categories we mentioned, which were temporary protected status, VAWA self-petitioners, refugees, asylees, or URT visa holders. I just want to be clear, I saw the DACA question. I just want to make sure people understood that.
Yeah, thank you. And feel free to chime in, anybody from the panel.
I did see one question in the chat from Eric. After how many quarters is a sponsor still responsible for an immigrant?
Yep. So there's a lawyerly answer and there's a quick answer. So generally speaking, it depends on who you sponsored. So if I sponsored my child to immigrate, and while my child is under 18, all the quarters that I am working count towards the quarters for that person. If I immigrate my spouse, all the time during the marriage that either of us are working, those quarters count combined. So it could be not just how many quarters has the sponsored immigrant worked, but it could be how much the sponsor has worked added in there. So I can't give you a good answer. Sorry, it's not clean.
Thank you, Miko. But also wanted to open it up and see if there's any additional questions, if there's maybe any CalFresh related questions, public charge.
Anna, I saw it's one of the common questions, but that fifth one, does getting a CalFresh affect my ability to get citizenship or a green card? So I mentioned it earlier, but just to be clear, there's 3 opportunities at which someone is subject to the public charge and disability. It's applying for a visa, applying for admission to the United States. So when you come to a port of entry, when you apply for admission, and then when you try to adjust status, so getting a green card. That citizenship application, we are not going to ask, you're not subject to public charge. So that question, getting CalFresh is not going to affect any of that because it's not one of those 2 programs. But just to be clear, as applying for naturalization, that public charge and disability, is not a part of that process at all.
Okay. And I see a question, if you apply to PACE, does it count as public charge?
So this one is, I'm gonna try to find this, and there's a section of Medicare, Medicaid, I think, and Miko probably knows this better than I do, but it's LT, long-term LTSS, I think it's called, but it's this series of, it's like care for people who are mentally challenged, people under the age of 18, over 65, in institutional environments. So that is the subsection of Medicare that we're looking at. So PACE, if it's for medical or some other kind of thing, unless it's income maintenance, we're not looking at it, or if it's that subsection Medicare. So if it's any other thing other than resources, cash payments for income maintenance, or that Medicare subprogram for long-term, I think it's long-term, it's LTSS, but long-term institutionalization, we're not going to look at it. So if it's not specifically in the rule, we're not going to look at it.
Thank you, Jeff. And Does anyone else have any other questions? Please feel free to unmute yourself as well. I'll put it in the chat. Want to make sure we get all questions answered. While we have the experts in the room with us. If someone, an elderly individual is in the States but no papers, can they apply for CalFresh? So if they don't have immigration status documents, it may be difficult for them to apply for CalFresh if they're not under qualifying legal status. It does, do you have a immigration status in mind for this person, Beatrice?
No, what happened was I tabled at the Linda Vista Farmers Market once, and I had an elderly man that came to me, and he wanted to know if he could apply for CalFresh, because I believe during the COVID, we came out, the CalFresh came out with a no legal status that people could apply for CalFresh back then. So they were wondering if that still qualifies for them. His daughter lives here, but his daughter does not want to get involved and doesn't want to do anything.
Yeah.
So he was wondering if he can apply by himself. He's about, I would say, 70 years old. And I was mute. I just couldn't
Yes.
respond because I didn't know if that regardless of the legal status, people could apply during COVID. I don't know if that's still, if they can still do that.
Yeah, so unfortunately, he cannot apply for CalFresh, but there is the CFAP Food for All expansion for undocumented individuals over the age of 55 plus. The implementation date for that is like very far in the future. It used to be 2024, but I think they're pushing it to 2027, where folks can apply for the California Food Assistance Program. But I will say that he is eligible for senior meal programs across San Diego County, where immigration status is not considered, and also food distribution programs, so that there are options for him.
He goes to food distributions, but sometimes there's not enough. Any chances you can put a link so I can have it with me?
Yeah, let's look at the senior meal programs at San Diego County.
Beatrice, if you'd like to send Shelley your email, we can send you links to the food distributions and to the elderly meal distributions. But I do recognize that it's 2:30 and I want to be respectful of everyone's time. So I do want to just first of all thank Jeff, Anna, and Miko for being here. It is so great to have all of the experts here in the room with us, and we are so grateful that you decided to collaborate and provide your expertise to everyone. And Lisa, we will share the recording after this presentation is over, along with all of these slides from USCIS, our slides from San Diego Hunger Coalition, and Miko's slides from Legal Aid. So we will be sharing all of those after the presentation is over. Thank you so much, everyone, for being here. Oh, and thank you so much to Luisa and Anna for providing their Spanish translations. We wanted to thank everyone so much. Thank you for bringing your expertise here to our event.
Thank you very much.
Thank you, everybody. Hope you have a great Tuesday.
Thank you. All right. And I will stop sharing my screen. And thank you.
I think we can stop the recording.